So today we'll talk about collaborative law and the situations where it makes sense, particularly if you're a business owner or have business interests that you need to keep out of the public spotlight. And don't we want to keep all of our private life out of the public spotlight? And also in situations, a lot of co-parenting is benefited in collaborative law. If we can go to the next slide, Stephanie. The the stakes are highest when you've got relationships that need to be protected, such as business relationships, co-parenting relationships, where you need to get into a realm where you can move forward and keep things private so they don't keep coming up at you again and again and again. In the business scenario, you don't want your confidential information out there for the world to misinterpret. You don't want your competitors or your vendors to be looking at your private business data. And no matter how much it's filed under seal, some of that is available in the public record if you litigate. Additionally, one of the things that we can do, one of the things that happen in litigation, if we're running through hearings and trials in the courtroom, we're taking focus away from your day-to-day. We're taking focus away from your business strategy and from your life. In collaborative law, we have zero public courtroom hearings. Everything is done away from the court. 85% of collaborative cases reach a final agreement without having contested motions. And we'll talk a little bit about why that is in a few minutes. Contested hearings increase your costs both emotionally and in dollars and cents. One of the statistics is up to a 60% reduction by using collaborative law as opposed to fully litigating. And there's one unified team. That doesn't mean that you and your ex-spouse or soon-to-be ex-spouse don't have differing views of what the outcome should be, but it means that we're getting there with one team, with one process. Everybody's on the same racetrack, everybody's on the same path to get to that result. And just by its own nature, if you deal with teams, if you deal with leading entities, you know that leads to cost reduction because we're not having to try to herd the kittens all back into the same road. Stephanie, if we can go to the next slide. Today we'll cover what collaborative law is and isn't, how it differs from the traditional litigated model, why it in particular fits executives, founders, and high earners, a little bit about what the collaborative team and the process look like, and how that all benefits the privacy, reputation, and career, particularly in entities where there are either business secrets, trade secrets to protect, or other information that we really don't want leaking out into the world. And I'll give you an example. I've got a case that I handled. A client owns a business. We were not able to bring this into the collaborative model because it does take agreement on all sides. The case is running a little over 2 years. There were competing experts. At the end of the day, we had to argue points about back income taxes, about spousal maintenance, about child support. And as I had warned my client, this is a business where the client was able to make and use significant sums of money, well in excess of what the district court judge is earning. So there wasn't a lot of sympathy for our client. In a collaborative law position, we don't have to depend on the court having sympathy. That's a very high level analysis of that case. Let me tell you a little bit about what collaborative law is. Collaborative law is not mediation. It's not a nicer divorce per se. It's a legally distinct process with a four-way agreement between both parties and their attorneys that we're not running to the courthouse. We're not filing contested motions. We're not, doing the, oh yeah, let's see what the judge says about that. This four-way agreement says that at the point where somebody says, I'm done with the process, I'm going to file something in court, both attorneys have to back out. Both parties need to get new counsel, and you start over. When we say you start over, most of my collaborative divorces, we've started by filing the petition or complaint for divorce in the court, identifying that we've got the collaborative agreement in place. So court, yes, I know you're supposed to actively manage cases. Please put everything in abeyance until we tell you otherwise. And then usually we are able to bring back a collaborative agreement and file it with the court and have the decree entered and all the agreements entered without any further interaction of the court. About 15% of the time, cases will do what we call falling out of the collaborative process. The collaborative attorneys back out. The parties get litigation attorneys. And then the cost, the emotional toll, all increase from there. Collaborative law does have its own rules, which is why not just any attorney can do a collaborative case. Some will say, oh yeah, sure, I can do it. I know how to do that. If they haven't been trained, they don't know what's normal and what's not normal, and they may try to force litigative procedures into the collaborative process. Generally, that gets smoothed out because the collaboratively trained attorney will help try to bring things back. But you do want somebody who's gone through collaborative training. I went through my collaborative training when I was in law school. I recognized that collaborative law is a benefit in certain instances. It's not for every case, but it's a benefit in certain instances. And I've actually seen it work wonders in reducing the tension, getting results that meet people's interests, and moving the case forward. That meeting the parties' interest is really important. Marriage that has become irretrievably broken generally has some characteristics. Communication is broken down, trust is reduced, and the goals and objectives of each party are going, other than getting out of the marriage, are going to be not necessarily the same on each side, but because trust and communication have broken down, each party may assume they know what the other side wants or why they want it. For example, very often one spouse says, well, I have to keep the marital home. I want the children to stay in the marital home. I don't want them to have to make new friends. I don't want them to have to go to new schools. These are usually the reasons underneath. But the party who's trying to keep that home oftentimes can't afford it. So that's where getting into the interest and making it an interest-based process can help us to figure out, given what we have in this marriage, what assets, what debts, and what interests, how do we create that individualized separation agreement, parenting plan, and divorce that's going to work for these parties without escalating all the tensions? Okay, so that's what collaborative law is. On the next slide, we've got some more detail about what collaborative law is. It's a legal process. It's governed by the participation agreement, holding both spouses, both attorneys in the process. It's an out-of-court commitment. We're not going to go running in and have the person in the robe deciding things for us. It's built around one single neutral team. If we need to value a business interest, we're not going to have each party running out and getting their business valuator signed up. And then when we get those business valuators and don't agree on the figure, getting another expert. We're not going to have competing appraisals. We're agreeing on one set of experts, one neutral set. If we need, we can also, in collaborative law, maybe we've got someone who's been a stay-at-home spouse. Maybe, one spouse started staying home when children were born. They've done volunteer work. They've been out of the workforce. Maybe their industry has changed tremendously in those years. Do we need to get somebody who can counsel and advise that spouse on how they get back into the workforce, on what education they need? Again, interest-based. What is going to get this newly structured family unit across this divorce bridge to being able to walk that new path without making it Sherman's March on Atlanta, without burning everything down? So some of the experts that might be engaged may be to counsel one of the parties on what they need to survive and thrive separately from the marriage. How do we make that happen then in our separation agreement, in our settlement? There are a series of structured four-way meetings with specific agenda about what we're going to address in each meeting. Between those meetings, the parties have homework. The parties are going out and learning about what it's going to take to get to the other side, what it's going to take to disentangle and enable them to thrive. Because at the end of the day, that's what we all want, right? We want to thrive. The focus is on the interest. So, of course, one of the first sessions is to identify the interest. Identify, why are we thinking we need this particular outcome on each side? It's designed to bring forth a durable, functionable, specific agreement for this family, for the new family structure. You may be thinking, well, in my situation, we can't do that. We've got emotions. Somebody stepped out of the marriage, or somebody spent the family into oblivion, or things like that. One of my first collaborative law cases, long-term marriage, series of infidelities by one spouse. The other spouse was disabled, unable to work. They thought that they had, after I'll call them the disabled spouse, after the disabled spouse found out about what was supposedly the last infidelity. They thought they had healed the marriage, that the one spouse was no longer stepping out. Found out, no, that wasn't true. They just hid their infidelity a little more. A lot of hurt feelings. These folks had adult children and grandchildren, and they were expected to be in the same room for holidays going forward. We were able to successfully use the collaborative law process. The first four-way session, you would have thought we had an electric generating machine in the room. I mean, the atmosphere was that thick. At the end, when they signed their settlement and the stipulations that we're filing with the court, they were actually able to hug each other and agree that they were moving forward in the best way possible. There was a lot of work in between, but they were able to do that. Although collaborative law uses mediation principles, it is not specifically mediation. In some cases, we'll use a neutral facilitator, not a neutral mediator per se, but a neutral facilitator in the four-way meetings or in some four-way meetings. Again, it's the principle of identifying what is needed in this case to help everybody keep moving forward. It's not simply litigation with civility. There's no running into the courtroom and getting the person in the road to decide based on where we are today. There's a structured process, and it's not casual. I mean, you can be informal, don't have to show up in a suit to these four-way meetings necessarily. But there's a purpose to every meeting. There's a purpose to every session. And the idea is to keep moving forward. I find that my clients who do best in collaborative law are the ones who can recognize that they're going to have to dig deep, that it's not weakness, softness, a lack of faith in their position that brings them into that process, but a willingness to say, look, the marriage was a private thing, the divorce is a private thing. I don't want somebody in a robe who's got at most a day or two to get to know my family and my case to try to be dividing things up. I want this to work for all of us, and most especially myself. So it takes some real confidence in your ability to work through a process. This is not a way to avoid disclosure. Full disclosure is necessary in the collaborative process. It's statutorily required in Colorado through our sworn financial statements, in Wyoming through what they call Rule 26 disclosures and confidential financial affidavits, and in Texas through the rules requiring disclosure. Disclosure is necessary in order to know what we have to divide in the marriage and to know how we're going to properly provide for any children in the marriage, if they're minor children. Disclosure makes sure that we are reaching agreements truly based on interest and getting the best division, the best result, as opposed to what we're hiding. Anytime someone tries not to disclose things, it generally backfires. That's when a case will fall out of the collaborative process. There are no guarantees. Any process works best when approached honestly and earnestly by the participants. However, it's the disqualification clause, the idea that at the moment that anybody says, okay, fine, we're going to file motions in court, that the attorneys the collaborative attorneys have to back out and litigative attorneys take over, brand new litigative attorneys. Generally at that point, you're invested in the solution that you've started working towards, and having something that's not just the cookie cutter that our district court and judges and magistrates can give you. I was recently in a meeting with some judges and magistrates, and they were telling me in Colorado, we have Colorado Supreme Court says that after a contested hearing, the court is supposed to issue their order within 30 days. A lot of these courts are not meeting that. I had one that was 6 months. In Wyoming, they don't have a specific guideline, although 30 to 60 days is their target. I had a case that we waited 13 months for a decision letter. The courts are simply overwhelmed and waiting for their answer, for their order, can be quite a long time. Collaborative law, again, gives you that sense of control. It allows you to craft a solution, a resolution that more specifically meets your situation. The court doesn't have time to think about, well, what really meets the situation, other than, well, I've seen these things before, and this is what we usually do. Not that the judges don't want to meet your situation, they just don't have time. So let's move into why this fits executives, founders, and high earners. What specifically in your background, your situation, makes collaborative law such a good fit? First of all, it's private. Even though there's still a requirement for disclosure, when we go to file the required documents in court to support our settlement, we can roll things up to a higher level so that people are not able to look in here and go, oh, this person values their trade secrets at this amount, or this person has, these specific things in their debt profile. We can keep things more confidential while still meeting the disclosure requirements, while still getting enough information to create a resolution that meets your specific needs, that restructures your family the way it needs to be restructured. If you're a business owner, if you're a high earning executive, there are things in your financial profile and in your background that just don't need to be filed in detail in the court. Complex compensation. You may have stock units, you may have deferred compensation, you may have, all kinds of unique or reasonably unique compensation models where the money isn't flowing into you today in exactly dollars and cents or spendable dollars and cents. There may be restrictions on them that the court interprets as, yes, it's still divisible, or no, it's not. There may be some reasons why the settlement needs to be drafted with payouts over time or contingent payouts. The court may or may not have time to think about, how does this apply? How do we fit this with the way case law has interpreted various complex compensation strategies? And depending on the level of risk and what amount of control the business or yourself have over that risk, you may want some really unique and individualized terms in the settlement. Business and equity interests overlap a little bit with the privacy and confidentiality and the complex compensation. And again, working with a single set of experts, one spouse, the spouse who's not involved in this business may not really understand. There may be a reasonably high level of living, high standard of living based off this income. But when we're trying to split into the new family units, they may think, okay, well, great, I want to keep this standard of living, and they may not understand why that's not possible, and experts can explain that. And when we're leveraging off one set of experts, it makes it reasonable to bring that one expert in and explain, look, this is the adjustment that really has got to be recognized. And you don't want your work colleagues or your business environment disrupted with subpoenas and audits and demands. I mean, nobody needs the business to be sidetracked by, oh, what's going on with, this party's divorce. Oh my goodness, are we going to have to be sold to deal with it? Privacy. Keep it, quiet, keep the circle close while still meeting disclosure and helping both parties understand the realities of the division. The overarching thing, one of the reasons we want privacy, confidentiality, and to minimize disruption to the business, reputation and career. I mean, a business person like yourselves can survive this sort of emotional upheaval, this disruption, if we don't have to keep coming back and fighting the reputational issues, if there's not a lot of back and forth and mudslinging going on to where people are going, oh my goodness, is this person still going to be the same person we thought they were? And I would add to all of this, control. The minute you step into a courtroom in front of the person in the robe, you are no longer the person in control. Your attorney is no longer the person in control. That person in the robe is the person in control. And they know this much of all of the information that's been gathered, of all of the information you know. So keeping it close, using one team of experts can help you get to the other side with the least disruption to your professional life. Let's talk a little bit about the team and the process. I've sprinkled a little bit in there. But from sign up to a signed agreement, typically this can be around 4 to 6 months. Again, it's going to be individualized. It's going to start with consulting about, is this the right process for you? Will the other side agree? Can we provide them with some names of collaboratively trained attorneys so that we can have a well-functioning team? Signing the participation agreement, getting the ground rules in place, starting with, that first session. What are the interests? Where are we headed? Separating out positions from interest. When I took my mediation classes, we talked about 2 kids fighting over an orange, and the parent came and whacked the orange in half and gave it to the kids, and neither one was happy. Well, turned out one of the kids wanted the zest from the orange, the outer peel, to bake a cake, and the other one wanted the juice and whacking it in half. Neither one had enough. Did not get to the interest before creating the solution. So getting to the interest is more than the position. Building the neutral team. I talked about the neutral team. Business evaluator, vocational evaluator, if a person's been out of the workforce, maybe a vocational counselor, so that a person who's been out of the workforce can understand how they're getting from where they are to self-sustaining. Maybe you've got minor children and we need somebody who can come in and help advise about the children. One of the things in collaborative law, if your children are of a sufficient age, I have had collaborative cases where we have brought the children into one of the four-way meetings to allow them to express themselves about what they want, about where they want to go in the outcome. And little spoiler alert, no matter how bad a parent either one is, most of the time, 90% of the time perhaps, those children want a relationship with both parents. So, if you feel out of control in a divorce situation, think about your children who are getting no information and sharing information with your children the court finds to be very objectionable, and feeling like they have no say in what's going to happen to them, where they're going to end up, whether they can even continue their activities. Giving the children the opportunity to say something appropriately with the right experts can be helpful in the process. Financial experts. If one person has the greater earning capacity, if and the other one doesn't know how they're going to make it from today's age to the end of their life, a financial planner might be needed. These are all experts that can be brought in that help us get from the marriage is broken and we just can't deal with it to a settlement that works with your newly structured family. There will be information gathering meetings and information gathering homework. There will be development of options. There will be refinement of options until we finally get to the point where we draft settlement documents that are ready to be filed with the court. We've talked about how this is all very privacy based. Some of those settlement details that end up getting filed with the court may be written in a way that keep some of the details private. Still enforceable by the court, but if it's got to be filed with the court, it might be filed under seal, or it might reference another document. These are all things that the legal folks help drive going forward. So that's kind of the process. We've talked a lot about privacy, reputation, and career considerations. We probably don't need to go greatly into that, but any process in the legal system has some limitations. The settlement communications are privileged. The disclosures stay in-house to the largest extent.
Hey, Heidi. I'm just checking in to make sure that we're here. I hope I didn't lose you, but if I did lose you, we're going to stand by so you can rejoin.
Settlement process. Let me see.
You're good. You're back. We're good.
in the settlement process, some of the things you'll still need to manage. If you've got a closely held company or if you've got co-founders, you may need to give them some notifications. You're going to have to manage that. You're going to have to manage some of the tax and wealth coordination. The narrative within your business, that's going to be something you're going to manage. Updating your estate plan may need to be done. There are only certain things the law automatically. Okay. Stephanie, are you able to see me now?
Yes, you're here. You're good.
Okay. So on slide 11, I mean, this is a pretty good summary of the items that you'll still need to deal with outside the process. A lot of it is dealing with what has to be disclosed within the business to your co-founders or other folks. And a lot of it can be fairly high level, but you'll need to look at your business's governing documents or your employment documents. And depending on your business, you may have to have some public facing PR strategy. Those are things we wouldn't handle in the collaborative team. I think we are about at the point for questions.
Hey, Heidi, yes, we are. And I actually have a couple.
Okay.
So question number one for attorney Heidi Whitaker. If my spouse and I are both wanting to divorce collaboratively, who hires the attorney? Do I hire it? Does he hire it? Do we both hire it? How does the hiring work?
In the collaborative law process, you still have your own attorney. Each party has an attorney. So that's why it's a four-way agreement, because husband, wife, or spouse one, spouse two, and the attorney for each of them. That's part of what is happening outside of the four-way meetings, is that each spouse is working with their own attorney regarding what information needs to be gathered, where are we in the process, what are our goals, what information do we need, are we still aligned with your interests, how do we get back to alignment with your interests to move that forward. So there are two attorneys and you each hire your own. If you're the first one saying, hey, I think I want the collaborative process, your attorney can help provide some names for other collaboratively trained attorneys that your spouse might want to talk to.
Thank you, Heidi. So great question and good explanation. If I need to modify my custody, can I still go collaboratively if my spouse and I agree to the most of the edits?
Yes. A modification of custody could still be done in the collaborative process. That might not be a 4 to 6 month process. That might be a little shorter. And if you're walking in with a lot of agreements, that certainly is going to make the process more streamlined. The collaborative process is very good in custody arrangements because it helps to dissipate the tension between the parties and keep everyone focused on interest and restructuring the family.
Thank you, Heidi. So those were the two questions that came in during your presentation. I think that's all we have for today. Thank you very much, Heidi, for joining us. If you just want to leave us with anything else for anyone thinking about going collaboratively, when is a good time to contact us as we close out?
At Johnson Law Group, Johnson O'Keefe, we have a process called legal coaching sessions. If you're not quite at the point of beginning a divorce or a family law process, but you're thinking that when you're ready, you want to go into the collaborative process, we could do a legal coaching session to explore how that fits your goals and objectives. Divorce is by nature an ending, but it doesn't have to be terminal. The idea is to get to the other side of that bridge in a manner where you can survive and thrive. And collaborative law is one of those methods.
Awesome. Thank you for that, Heidi. So please, anyone that's exploring separation or just learning more about divorce, please schedule a consultation. We do take complimentary consults with our intake team, and then we'll assess what is right for you or what options we have to get you some help. And we will have this webinar on replay here soon. And we actually have a webinar coming up next Thursday with attorney Jason Thatcher. He is great, just like attorney Heidi. And we look forward to connecting with y'all. Thank you so much, Heidi, for joining us and taking the time.
Thank you. And I thank all of the participants for spending some time learning about collaborative law.
Yes, outstanding. Thank you, guys. And we'll see you next week. Take care. Have a great rest of your day.